The following is a presentation by yours truly, President Christina Grappo, Native American dispute concerning reservation easement. The easement on reservation dispute is concerning a Native American easement dispute. The indigenous Lac du Flambeau Band of Lake Superior set up 4 roadblocks on January 31st, 2023 in its dispute with First American and Chicago title companies of right-of-way permissive entry agreements on tribal land roads. Tribal leaders stated they were being illegally used. The United States Department of Justice filed a lawsuit to force a northern Wisconsin town to pay unspecified damages for failing to renew access easements on Native American tribal land. This is part of a long, ongoing dispute between the Native Americans and the town of Lac du Flambeau. Easements expired 10 years ago, and the tribe only wanted to make 25-year agreements. The title companies and town roadway point of view brought a lawsuit forward. The lawsuit against the tribe to remove barricades did not pan out, though. The United States District Judge William Conley in Madison, Wisconsin, did not force the tribe to remove barricades. In an order issued August 15th, the judge dismissed the lawsuit and sided with the tribal council, pronouncing it had sovereign rights over the roadways and also that a federal court does not have the legal or federal jurisdiction to force Lac du Flambeau natives to keep the roads open to the public. This is an example of one of the tribal roads barricades. Is this a violation of servitude? Easements are servitudes that limit the right of entry and utilization for a specific purpose, land that is owned by another. Here, the Lac of Flambeau Native Americans had an agreement with the town that permitted roadway exploitation through its reservation. However, the agreement expired 10 years ago, and they no longer wanted such travel unless they were paid $20 million for a right-of-way easement from the title companies. Therefore, there was a violation of servitude for the tribe. By custom and agreement, the title companies were used to having open roadways and were suddenly blocked from using them, so there was a violation of servitude from their perspective as well, but they should have formed a more solid agreement before. Thus, the Lac du Flambeau band ought to receive damages. Here is a picture of the banner sign on one of the barricades. Property law principles above and beyond the scope of our coursework concern the synopsis of Wisconsin Easement Law 2021, Wisconsin Act 174, and the Wisconsin Reservation Roadway Dispute. The new law only pertains to access easements. Access easements are easements chronicled for the purpose of providing vehicles, bicycles, and/or pedestrians the permission to cross intervening property. Access easements often provide access to landlocked parcels, which is the case for the Wisconsin Reservation that owns the roadways. The law safeguards the freedom to contract because it is against public policy to terminate a contract that was not re-recorded after 40 years. The law is only applicable to recorded access easements at the County Registrar of Deeds on location. Access easements chronicled on or after January 1st, 1960 run in perpetuity according to terms. If the access easement agreement provides a specific termination date for the easement, then the easement agreement controls the legal enforceability. The legislation is retroactive for applicable access easements. This is the fight for the Lac du Flambeau tribe and reservation. The legislation applies to current and recent legislation. Litigation already resolved prior to the bill's effective date, March 13th, 2022, is not affected. The indigenous reservation is affected. And here is a picture of Wisconsin's Lac du Flambeau Ojibwe Nation. And finally, the resources include my bibliography list. This concludes my presentation. Thank you and goodbye for now.